from the initiation of petitions against 38 legislators of Shinde faction by the UBT faction. Shinde faction had an overwhelming majority of 37 out of 55 MLAs with the when the rival faction emerged. From my analysis, observations, conclusions and findings recorded in paragraph 82 to 144 herein above, I hold that Shinde faction was the real Shivsena political party when rival factions emerged on 21st June 2022. In view of my findings,
राजकीय पक्ष म्हणून शिंदे गटाला मान्यता देतो असं विधानसभा अध्यक्ष नार्वेकर यांनी म्हटलेलं आहे. मूळ राजकीय पक्ष म्हणून शिंदे गटाला मान्यता.
From 21st June 2022, I further conclude that Shri Bharat Gogawale was validly appointed as the whip, as that was the reflection of the will of the Shivsena political party as on 21st June 2023. Following are the final conclusions, which is again a summary. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? I will also read the final conclusion. Following are the final conclusions from the analysis, observations, conclusions, findings and rulings recorded from paragraph 82 to paragraph 158 herein above. I conclude as follows. Shinde faction was the real Shivsena political party when the rival factions emerged on 21st June 2022. Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022. Shri Bharat Gogawale was validly appointed as the whip of Shivsena political party on 21st June 2023. Shri Eknath Shinde was validly appointed as the leader of the Shivsena political party on 21st June 2023. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? Petitioner has contended that the respondents are liable to be disqualified on various grounds. Both the petitioners and respondents' submission are recorded in section 2 herein above. The various grounds on which the petitioner based the plea for disqualification is dealt with, where the alleged conduct of the respondent is purportedly becoming totally incommunicado, attracts disqualification under paragraph 2(1)A of the 10th schedule. Whether the alleged conduct of the respondents in purportedly becoming totally incommunicado attracts disqualification under paragraph 2 subclause 1 subclause A of the 10th schedule. The first ground on which the petitioner sought disqualification of the respondents is that the respondents became incommunicado. The submission cannot be accepted and the respondents cannot be held to be disqualified on this ground for the following reasons. The ground is a mere allegation, and apart from mere assertion that the respondents have gone incommunicado, the petitioner has not put forth any evidence or material to substantiate it. For instance, the petitioner has not provided any material about who was sought to be contacted and by whom, when such an attempt was made, etc. A mere unsubstantiated statement that the legislators have gone incommunicado cannot even be a ground to attract disqualification under paragraph 21A of the 10th schedule. When rival factions emerge in a political party, especially within the leadership, it is possible for both the factions to allege that the other faction has gone incommunicado. In such a circumstance, especially in the light of the law laid down by the apex court in Subhash Desai Supra, it would not be correct to hold any faction to have incurred disqualification for going incommunicado without first determining which of the faction is the real political party, reflecting the will of the political party. Also, having held that the Shinde faction was the real political party when the rival factions emerged, the submission of the petitioner that the respondents have gone incommunicado ceases to hold any meaning for the purpose of disqualification. On the 20th of June 2022, elections for the Legislative Council were held. In his cross-examination, Shri Sunil Prabhu, PW1, stated that all the MLAs were present for the same. In the face of this evidence, it would not be possible to accept that the legislators had gone incommunicado. Respondents have placed that they have been in touch with the UBT faction. They substantiated it by stating that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents on 21st June 2022 on the instructions of Shri Uddhav Thackeray. This fact was not denied by the petitioner, Shri Sunil Prabhu, when a suggestion was put to him in the cross-examination. In fact, the petitioner admitted that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents. Also, three of the witnesses for respondents have testified that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents. On 21st June 2022, on the instructions of Shri Uddhav Thackeray, the testimony stood the test of cross-examination and the petitioner could not establish otherwise. Thus, on this count alone, or this count also, it would not be possible to accept the legislators were incommunicado, to accept that the legislators were incommunicado. Whether the deliberate absence of the respondent in the SSLP meetings purported to be held on 21st June 2022 attracts disqualification under paragraph 21A of the 10th schedule. The second ground on which the disqualification is sought is that the respondent deliberately remained absent in the SSLP meeting held on 21st June 2022. Petitioners relied on the attendance sheet register of the meeting dated 21st June 2022. After having considered the submission advanced on this ground, I hold that respondents cannot be held to be disqualified on this ground. In view of my conclusion that 1. The Shinde faction was the real political party when factions emerged, and 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment the faction emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 is liable to be rejected. Irrespective of the conclusion that may be reached about which faction was the real political party, respondents could not be held to be disqualified on the ground that they deliberately remained absent in the SSLP meeting held on 21st June 2022. This is because of the following reasons. Petitioner relied upon the attendance sheet of the 21st of June 2022 to claim that all those MLAs who were signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, the UBT faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu, PW1, with the copy of the attendance sheet produced and verified as a true copy along with the petition, reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten date of 21st June 2022, whereas the copy verified as the true copy of the original produced along with the petition does not have it. Further, Shri Sunil Prabhu stated in his cross-examination that the documents relied as the attendance sheet was in fact a register of MLAs to whom the whip of 21st June 2022 was served and received. So, facts show: 1. there are glaring discrepancies in the said attendance